great.
So give us a moment. All right, we'll just go ahead and get started. I know a few people are going to start coming in, but I just want to be respectful of everybody's time. And I know we have some good information that you want to share, John. And so thank you so much for your time. And so, so everyone that's on the call today, thank you so much for attending and joining us for our SoCal CCIM, our update on SB 939. And I know there's a lot of questions that are focused around this topic. And we're excited to bring you an update as to where everything's at today. And so before we get started, yeah, thank you, John. So before we get started, I'm just going to go through a couple of slides here for our CCIM. So just want to remind everyone what the mission statement is of the CCIM, which is the mission of CCIM Institute is to elevate our members to the highest levels of success in the commercial real estate profession. And that's exactly what we're doing here. We want to bring the latest and greatest information to our members and to the commercial real estate community. We do have a couple of media sites, social media sites that everyone could follow us on, Instagram, Facebook, Twitter. And those of you that are on, if you'd like to get a copy of today's recording, you will see it on our YouTube channel. It's a SoCal CCIM YouTube channel. And you just go on there, you'll get this recording along with all the other recordings we've done. And so we've been creating a nice library. Also want to give recognition to our board members. There's no way we could do the things that we've been doing without the influence of our board. And so we just want to thank everyone for their participation. And we're very excited to have everyone a part. Also very, very important is we want to give recognition to each of our sponsors. And there's no way we could do the things that we do without the support from our sponsors. And so if anyone has any questions or have anything related, our sponsors would love to hear from you, and we definitely want to go out there and support our sponsors just as they've been supporting us. And so also want to throw this out there as well. We started a reciprocal chapter membership. So if you are a chapter member of NorCal CCIM, San Diego, Hawaii, New Mexico, wherever you're at in the country, if you are a member of CCIM, and if you'd also like to be a member of SoCal CCIM, you can easily do so for $25. If you just go to SoCalCCIM.com, you could go ahead and apply for membership, and then you could become a member, and you'll get all the information and all the benefits that we have straight to you. And so that's something that we're really excited about. So, all right, with that, just want to go ahead and introduce John Baker, Baker Law Group. I can say John's been a wonderful resource for myself personally, for my business, and for our chapter. And I can't think of anyone else that could do a better job and give us information than John. So John, take it away.
Thank you. Yes, I want to share my screen here. So my name is John Baker. I'm a real estate attorney here in Orange County. And today we're going to talk about Senate Bill SB 939 and talk about what it says it wants to do and what you can do about it.
Hey, John, I'm sorry, and one thing I forgot to announce is that for our participants, if you have any questions during John's presentation, you could use the Q&A box to go ahead and type in your answers. At the end of the presentation, John is willing and able to answer some questions live. So if you have any questions that come up, just go ahead and raise your hand, and we'll go ahead and bring you in so you could ask your question live. Or again, you could use the Q&A box, and I'll ask those questions to John after. So sorry about that. John, go ahead, take it away.
Not a problem. So Senate Bill 939, it seeks to give rent relief to businesses to the detriment of landlords. One section, there's basically two major sections in this bill. One section benefits restaurants, bars, and places of entertainment, and another section benefits all, quote, small businesses impacted by the coronavirus pandemic. But small businesses are defined as 500 or less employees. That might change based on what the author of the bill said on Monday, just before the hearing before the Appropriations Committee on Tuesday. there's almost nothing in this bill that favors landlords. Let's talk about Section 1 first. And as with everything legal, you want to start with the definitions. And so what is an eligible COVID-19 impacted commercial tenant? We all know what a commercial tenant is. It's what you would normally think of it as, except that it also includes nonprofits. COVID-19 impacted, it means several things, or there's several components. It means a commercial tenant who's experienced a 20% or more decline in average monthly revenue over the 2 most recent calendar months when compared to the average revenue for the 2 months before the shelter-in-place order took effect, or for the same calendar months in 2019. Now, this is for Section 1. There's a different definition for COVID-19 impacted in Section 2, and we'll get to that in a few minutes. COVID-19 impacted can also mean a commercial tenant who has been prevented from opening its business because of the state of emergency. Notice that it says prevented, not partially prevented or restricted. So for example, a restaurant can still, during at least in the last several weeks, could still sell takeout. So they weren't prevented from doing business like a nail salon was doing. Another definition of a COVID-19 impacted tenant is also a commercial tenant who has suffered a 15% or more decline in capacity due to compliance with a public health order. This applies to both multinationals and mom and pops. You know, again, Weiner has said that he wants to tailor the law to more affect just mom and pops and not multinationals. That wasn't the purpose of this bill. Again, also notice that there's if you can show that you suffered a 15% or more decline in capacity, you don't have to show any loss of revenue. So a pizza parlor has a high volume for takeout may not suffer much of a revenue loss, but it could still apply for it. The state of emergency is important because it's used, the definition is used throughout this thing. It means the emergency proclamation that the governor made on March 4th. The problem with using this is that no matter how relaxed the state of emergency proclamation becomes, in other words, we're in stage 2, we're going into stage 3, there's still likely to be a state of emergency for months to come and maybe even years. This section is going to change according to Weiner. You know, this is what he said on Monday, but there's no new text yet, so we can't talk about it. A 3-day notice that's already been served on a commercial tenant from now through the 90 days from the end of the state of emergency would be void if the 3-day notice requires payment. So in other words, if the 3-day notice was served because of failure to pay rent or to failure to replenish the security deposit, that 3-day notice would be void. However, there's another little component that when the 3-day notice is served, the tenant was an eligible COVID-19 impacted commercial tenant. And the level of proof needed to show that is pretty low. This bill also affects unlawful detainer or eviction lawsuits. The bill would provide that a landlord would be unable to file an unlawful detainer or an eviction lawsuit on the grounds that a COVID-19 impacted tenant had failed to pay rent during the emergency. Right now, that would be redundant because there's already a rule under the Judicial Council, the rulemaking body of the courts. And under this rule, no unlawful detainer, residential or commercial, has been able to file a lawsuit for eviction since late March or early April. And that it won't sunset until 90 days after the state of emergency is lifted. On Monday, the Judicial Council wanted to end this rule and in other words, sunset it on August 4th and let the legislature take over this process of whether a residential or a commercial tenant could file a lawsuit for eviction. But the governor and the legislature has persuaded the Judicial Council that 2 months wasn't enough time for the legislature to get any legislation passed that would replace or supplant this rule. So we're back to the original sunset date of 90 days after the state of emergency is lifted. Again, back to the bill, during the state of emergency, a COVID-19 impacted commercial tenant's unpaid rent would be due 12 months after the end of the emergency. Now, Weiner has said that his intention is not that the rent, that his intention is that the rent be paid over 12 months evenly, and not a lump sum at the end of the 12 months, but this is not what the bill says. With late fees cannot be imposed under this bill on unpaid rent of a COVID-19 impacted commercial tenant during the state of emergency. There's, if rent is still unpaid after 12 months after the end of the state of emergency, then you get late fees for what that's worth. An important part of this is harassment's forbidden. A landlord cannot harass or intimidate or threaten or retaliate a commercial tenant with the intent to if the intent of that is to terminate the occupancy. Oddly enough, this piece of legislation, which is not the best drafted piece of legislation out there, but it doesn't say anything about serving a 30-day notice. But would that 30-day notice be harassment? We don't know. A landlord who harasses or retaliates can be liable to the tenant for actual damages and a minimum of $250 for each separate cause of action. Each separate cause of action is easy to do. So every time that an email was sent or a notice was sent by the landlord, that could qualify as a separate cause of action if the purpose of that email or that notice was to harass or retaliate with the intent to get the tenant to leave the premises. The other thing here is that in this harassment lawsuit that could be filed under this bill, the court must award a reasonable attorney's fees to the prevailing commercial tenant. It doesn't say anything about awarding reasonable attorney's fees to the prevailing landlord. Willful violations constitute an unbusiness practice under this bill. We're going to just strike the word willful because under current law and the structure or interpretation of willful, if the law is on the book and you violate it, it's willful. So we're just going to say that violations of this section of this law will constitute an unlawful business practice, which could lead to punitive damages, and it could also be an act of unfair competition. That could allow the lawsuit to be turned into a class action lawsuit. So in other words, if there's many tenants in the building, then the plaintiff could turn that into a class action with all the tenants in the building becoming the class. Lastly, landlords are going to be required, if this bill passes, to give notice to all their tenants that of the protections of this new law, and that has to be done within 30 days. Let's talk about Section 2 now. Again, the definitions. The definition for Section 2 of an eligible COVID-19 impacted commercial tenant means a small business that operates primarily in California and has a lease for real estate and is an eating or drinking establishment, a place of entertainment, or a performance venue. I'm not sure what the difference between a place of entertainment and performance venue is, but regardless. Note that this bill doesn't say anything about any of these three items being the primary business. So I asked the question, could a shoe store sell cookies and thereby become an eating establishment and qualify under this Section 2 as a COVID-19 impacted tenant? To be an eligible COVID impacted commercial tenant, the tenant must also have experienced a decline of 40% or more of the average monthly revenue over the past 2 recent months when compared again to the 2 months before a shelter-in-place order took effect, or for the same calendar months in 2019. Or it has been prevented from opening its business because of the state of emergency. That would be like a nail salon again. Or it has suffered a 25% or more decline in capacity due to compliance with a public health order. Again, there's no proof of loss that's required under this one. Small business, Weiner says, will be defined and it'll be tightened up. So what exists now may change to some degree. On this slide right here, I think, except for the next to last one, I think these will probably stay the same. In other words, small business is a business that is not dominant in its field, that has its principal office in California, whose officers are domiciled in California, meaning they live here in California, and it is not a publicly traded company. Right now, it also has to have 500 or fewer employees, which is the definition, the federal definition of a small business. But I think most businesses with 500 employees would be regarded as large businesses, and I think that's going to be tightened down to some much smaller number. The end date for Section 2, if it's enacted, would be December 31, 2021. That's roughly 18 months from now, or the 2 months after the end of the state of the emergency, whichever is later. Modification of a lease. This is a troubling section of the Section 2 of the bill, and that is that an eligible COVID-19 impacted commercial tenant who wants to modify his lease can engage in good faith negotiations with its landlord to modify any rent or economic requirement of the lease. And I think this is the part that's going to get changed. Under the bill as it exists now, if the tenant and the landlord don't reach an agreement within roughly 40 days, the tenant could just terminate the lease by serving notice and then vacate the property within 14 days later. Even worse, once the tenant vacated, the lease would terminate, there'd be no further liability for rent, and any guarantees would no longer be enforceable. And in fact, in lieu of other damages, the tenant would be obligated to pay within 12 months, no more than 3 months of the past due rent. The purpose, or Weiner says, the author says that his purpose was to give the tenant a little bit more leverage in negotiations, but he still wants to bring both the parties, the tenant and the landlord, together to work together to the extent that they're not already working together right now. So what can you do? You can call your senator, you can write your senator. These really do matter. You are really heard when you make a call or write a letter, because those are quantified. You can also encourage others to call or write their senator. And the names, the addresses, and the phone numbers of senators can be found at www.senate.ca.gov/senators. There's a template for a letter that can be found on the Commercial Real Estate Development Association's website, which is there on this slide. And for those of you who are in Orange County, here is a list of the 4 or 5 senators who represent Orange County and other parts of it. So with that, I'll take any questions.
John, thank you for that. You had a lot of wonderful information there, and information that is, I guess in summary, overall, I mean, if you were to summarize kind of what you talked about as far as what the changes are, how would you summarize that? Because I'm thinking about us brokers, because we have to explain this to our clients. And so, right. And without getting too technical, what our clients were, we get lost in our own words. Is there something that comes to mind that we could just give our client a quick summary without getting into the weeds? What would any advice you would have for us commercial real estate brokers that's trying to update our clients on this?
Well, as I said a couple of months ago, my recommendation is that landlords be upfront about all of this, or at least take the lead on this, and approach their tenants now about making payments and possibly deferring payments, because it doesn't help a landlord at all to get into a tiff with a tenant and not get any rent at all. The landlord is unable to enforce any breach of the lease right now, at least when it comes to payment of rent. So you might as well look like the good guy or the good girl and go out there and offer to do something for the tenant, rather than let the tenant take the advantage and not pay you any rent, and may have to wait for months before anything could happen. Because right now you can't even file an unlawful detainer. And while that looked for a while like that might end in a couple of months, in other words, you might be able to file an unlawful detainer in a couple of months, that's not the case anymore. So it's going to be probably at least 3 months before anybody can file an unlawful detainer. And then my guess, this is, pulling out my crystal ball, is that even when we are able to file an unlawful detainer, trials are not going to be set for at least 60 days and maybe even longer. So there isn't going to be any quick justice for a landlord. Therefore, you might as well work on getting the best deal you can.
So, okay, so if a property owner can't get a court date and a landlord is trying to negotiate with their tenant, and the tenant calls harassment on the property owner, I mean, is that tenant going to get a court date? Or is that tenant in the same boat as the property owner?
The tenant could get well, the courts are just beginning to open up. I think in Los Angeles County, for example, is opening up June 5th. Orange County has what it calls a slow opening right now. And so it's likely that it's likely that the tenant would be able to file the lawsuit much sooner than a landlord would be able to file a unlawful detainer. As to when the tenant might get a trial, that's a different question. I'm not sure that the tenant would get a trial much sooner or very soon at all. If the tenant filed a small claims matter, then they might be able to get a trial very quickly, within 30 to 60 days even. But that doesn't, I don't know if that answers your question. I'm not sure I can answer it any better though.
Yeah, well, that's helpful. And we do have a couple of questions here. And I see Rubix gave us a question during the middle of your presentation, and the question was, does a gym, MMA, or fitness club qualify? I assume this is having to be as an affected business.
Well, yes, at least right now, because a gym can't open and it's been prevented from opening. So that's definitely qualifying. There's conversation that gyms will be able to open within the next week or two with restrictions. And then you move into that second category of where they're not fully prevented from doing business. They just have to operate with restrictions.
Okay, and then it looks like we got a couple of questions and comments related to this one. This bill, if enacted, would expire on December 31st, 2021. That
was Section 2, I think, and that, and again, in the Section 1, I think the expiration date is 90 days after the state of emergency is lifted.
Okay.
Again, the Section 2 affects only bars and restaurants and places of entertainment, whereas the Section 1 affects all commercial tenants, big or large, big or small.
Right. Okay, and then Willie Hugren has a question, and he raised his hand, and Willie, are you there?
I'm here. So my question is, how does all this affect multifamily properties?
It doesn't, because the statute in its definitions says that it has to be a commercial tenant in a commercial building, as I recall. So if somebody is operating a business out of their apartment, that I don't think would qualify. assuming that they're doing it on, on the second floor, not on the base floor where there's other retail, mixed use.
I have a couple properties that, one is the rent is paid by Social Security for senior citizens. So it's a business in a multifamily property, and another one is a drug and alcohol rehab facility. So it's a quasi-commercial, quasi-residential situation. And the one that's getting their money from the Social Security isn't paying their rent. So it's really a challenge. And I'm told I can't evict them. I can't give them a rent increase. I can't charge them late fees. I can't do anything. And yet I still have to pay my mortgage, my real estate taxes, and I just got a supplemental tax bill for $9,000. I don't have the money.
Right. As you've noticed, this bill only benefits tenants. Part of the problem is that a state has huge challenges in trying to affect national banks or payments to national banks. It can't even put a maximum interest rate on nationally operating banks. So it's challenging to come up with or be creative enough to come up with a way to give landlords some relief when so much relief is being given to tenants, because that kind of relief would have to come from the federal government and not from the state of California. And that's why I go back to, not to make you wrong at all, I'm just saying that that's why it makes more sense to make a deal with the tenant than to try and go at loggerheads with them.
John, it looks as if there's multiple questions, and all these questions, it looks like it really relates to the type of business that would qualify as to what you're talking about. And so I'm thinking it might be helpful if you don't mind sharing your screen again as far as your section 1, talking about who specifically this would cover.
Okay. That will require some finding.
No problem.
So what was the question again?
Just what type of businesses that would this bill cover? Because we have questions.
The bill covers, okay, section 1, or let me start with section 2. Section 2 only affects restaurants and bars and places of entertainment. Section 1 affects all other tenants, assuming that they've been impacted financially by the COVID-19.
Okay, so Daniel,
you want me to get into the percentages?
No, so I'm just trying to answer some of these questions.
Yeah.
Some of the folks here has, one question we have, and I'll just tell you in kind of a shotgun order. One question: it seems to me that non-entertainment, non-food establishment properties are not affected by SB 939. Is that correct? Is a question.
No, this is what you're looking at is section 1,
right?
The definition of a COVID impacted commercial tenant, and this could be a multinational or a mom and pop. It just has to show a 20% or more decline in the average monthly revenue over the 2 most recent months when compared with another period of time. This is one of the sections that applies to gyms and nail salons, and this one is basically the easiest example, it would be a restaurant, but it would also maybe apply to a retail place that could only let in, a smaller amount of clients.
Right. And it does not apply to, you said, a company that is public or has more than 500 employees?
That's section 2 again. Sorry to,
Right.
it's so confusing, but
Right.
under section 1, there is no limitation like there is for section 2.
Got it. Okay. So one of the questions here, so a tenant such as Jack in the Box corporate store would be covered by this law.
If it experienced a 20% or more decline in average monthly revenue over the last 2 months.
Okay.
Under that's section 1. It probably would not apply to under section 2 because I don't think Jack in the Box is a California business or that, and many other issues there.
Got it. Okay, and then we have Diana with their hand raised. Diana, can you want to come in and ask your question? I'm trying to unmute you here, but okay, we'll come back to you. Another question is, when does this go to the floor for a vote?
It has not been set for that yet. There is a hearing on June 18th, I think, on this matter. So on Tuesday, it was in the Appropriations Committee. And the author, Senator Weiner, said that he was going to make some major changes to it. The analysis done by the Appropriation Committee people showed that actually that the state of California would be impacted physically if this bill went into effect. In other words, they might lose a lot of rent. And so as a result, it met a certain level. That means that this bill was thrown into the suspense file. Now, out of the suspense file on June 18th, it might go to the floor and it might just die. We're running up against a couple of deadlines, both for the Senate to approve it, and then it has to go to the Assembly, and the whole process has to start all over again. And August 31st is the last day that any legislation can be passed. So, let me also mention that even if SB 939 gets to the floor in the Senate, it will have to pass on a 2/3 vote. So at least in the legislative committee meeting, the author and everyone on the committee acknowledged that that was the high bar to pass. One of the reasons that Weiner has agreed to make all these changes last Monday was because of the, what he, quote unquote, this is his word, blowback that he'd gotten from all the commercial real estate stakeholders. So he has agreed, and that's why he's agreed to make these changes, is so that he can perhaps gather enough votes to get this thing to pass.
Right, and I know this is something that you mentioned before, but Christina says that she has a tenant that has not paid for April or May's rent. Landlord has offered reduced rent from May to December 2020, in which the $16,000 to be amortized in the next 48 months. Tenant won't accept the offer and insists landlord to abate this month or this amount, which I think that's pretty common to what we're seeing from a lot of tenants. Can you remind us what's the earliest date a landlord can file an unlawful detainer?
It's not a date certain right now. The Judicial Council was going to modify its ruling and change it to August 4th from 90 days after the state of emergency is over. That's not going to happen. So we're left with no unlawful detainer being able to be filed right now as we speak today until 90 days after the state of emergency is over. My feeling is that, and this is just my guess, is that after things start to open up more and more and the courts start to open up more and more, if the legislature can't get it together to pass these bills, like this SB 939, and there's another one for residential that's pending, then I think the Judicial Council will modify its date and in other words, light a fire underneath the legislature to do something. I think right now, if it were to pass, if it were to be modified right now, I think some version of SB 939 would pass. I think Weiner is under a lot of pressure to make it less overbearing for on the landlords, but there's definitely a notion that that tenants, both residential and small mom and pops, need to be protected.
So there was a big date that just happened this past Tuesday. What's the next big date that we need to be mindful of?
Well, the big date, so to speak, on Tuesday was the appropriations hearing,
Right.
Appropriations Committee hearing. It went into the suspense file along with a whole bunch of other bills, and I think it's June 18th, the same Appropriations Committee will consider whether to pull it out of the suspense file and send it to the floor or let it die.
And you said it needs a 75% vote for this in order for it to pass.
Two-thirds.
Yeah, 2/3. And so, and then you think that portions of this would pass, right?
I think if Weiner is willing to make the bill less draconian, then I think some respite would be given to tenants for the near future.
Right. Great. I see a couple of people are asking for a copy of this presentation and the slides. Just a reminder for everyone who's on this call, if you go to SoCal CCIM YouTube channel, there will be a recording of this video. So you'll get all this information. So in case there's anything you missed, it will certainly be on there. And so
let me add though, what I've given you today is current as of today. This thing has been so fluid. I mean, on Monday, the author says he's going to make major changes. On Monday, also, the Judicial Council says it's going to allow unlawful detainers to be filed as of August 4th. Then on Wednesday, the Judicial Council pulls back again. So to get these slides, they're going to be out of date within a week.
right. That's how fast it's moving, huh?
Yeah.
All right. So if anyone has any questions on this, John, what should they do? Should they, is there a resource that they could go to? Should they call you, or what do you recommend?
They can certainly call me. There's my email address and phone number at the bottom, 949-450-0444, or they can email me at jbaker@bakerlawgroup.com. I'll be glad to help them. Resources are abundant on the web. Just Google SB 939 and you'll be sure to find something.
Wonderful. And then I think this is going to be our last question, but does a legislator have to disclose whether they would benefit from the passage of this bill?
I don't know the actual answer to that. My guess is that they should. Well, my thought is that they should. I don't know. Since so many of them are impacted either as a tenant or a landlord, or they know somebody who is, or they have a relative who's a tenant or a landlord. I don't know what the actual rule is.
Right. And so, and then Nita's just reminding us to vote. By voting us down, we have to be proactive. We have to reach out to the National Association of Realtors, probably more so the California Association of Realtors, and just.
Well, also to call your senator.
Call a senator, right?
I mean, I think that's going to have more, at least as much effect as going to CAR. Remember, car is mostly residential,
Right.
not commercial. There's the Commercial Real Estate Development Association. I think, what is it? ICIS, I think, also has a template for a letter if you want to send them a letter. It doesn't, you don't have to say much. You can just write an email and say, I object to this. This is not fair to landlords. It benefit, we have mortgages to pay too. That's all you really have to say. All the arguments have already been made. I mean, it's unlikely that any of us are going to come up with some novel new argument that's going to change anybody's opinion. But if you register that you object to it, that's what's going to count.
Right. Wonderful. Well, again, John, thank you so much. I'm looking at our time. And so if you would show one more slide of your contact information so people know how to contact you, that would be great.
Well, I appreciate it.
Yeah, wonderful. Hey, John, thank you so much for your time. It sounds like we
Thank
need
you.
to get you on here again once we have some more information. But again, thank you so much. You've been a wonderful support for our chapter, and we definitely want to support you as much as you've been supporting us. So again, thank you everyone for your time, and we will see everybody soon. Thank you.
All right, thanks very much. Appreciate it.
See you, John. Thank you.